Please be seated.
Mr. Registrar, please call the case.
Je vous remercie, Monsieur le Président.
Thank you, Mr. President. The Appeals Chamber of the International Criminal Tribunal for Rwanda, composed of Judge Patrick Robinson presiding, Judge Mehmet Guni, Judge Fausto Pokar, Judge Arlette Ramaroson, and Judge Andresia Vaz, sitting this Tuesday, 8 May 2012 in open session to deliver its judgment in the matter of the prosecutor versus Gaspard Kanyarukiga, case number ICTR/02/78A. Thank you, Mr. President.
Thank you. May I have the appearances for Mr. Kanyarukiga?
Good morning, Mr. President, Your Honors. My name is David Jacobs. I have the privilege of representing Mr. Gaspard Kanyarukiga. To my right is Mr. Claver Sindayagaya, who is a former lead counsel in the case. To my left, Jean-Martin Ndahirwe, an investigator. And behind me, Mr. Kanyarukiga. Thank you very much, Mr. President, Your Honors.
Thank you, Mr. Jacobs. And for the prosecution?
Merci, Monsieur le Président.
Thank you, Mr. President. Mr. President, Your Honors, good morning. The Office of the Prosecutor is represented this morning by Mr. James Arguin to my left, Mr. Stephen Worth to my right, and behind me are Mrs. Lydia Mugambe and Berika, and yours truly, Abdul Say. Thank you.
Thank you, Mr. Prosecutor. Mr. Kanyarukiga and the prosecutor appealed against the trial judgment pronounced on the 1st of November 2010 and filed in writing on the 9th of November 2010 by Trial Chamber 2. According to the scheduling order of the 13th of March 2012, today, the Appeals Chamber delivers its judgment. I will summarize the findings of the Appeals Chamber, and I am to tell you that the oral summary does not constitute any part of the official and authoritative written judgment, which will be distributed to the parties at the close of this hearing. This case concerns crimes committed in the Nyanje sector, the Kivumo commune, and the Kibuye prefecture in Rwanda in April 1994. At that time, Mr. Kanyarukiga was a businessman who owned a pharmacy in the Nyange Trading Center. The trial chamber convicted Mr. Kanyarukiga of genocide and extermination as a crime against humanity based on his participation in the planning of the destruction of the Nyanje Church on the 16th of April, 1994. The destruction of the church resulted in the killing of approximately 2,000 Tutsi civilians. Mr. Kanyarukiga was sentenced to 30 years imprisonment. He has appealed against his convictions and his sentence, and the Chamber has identified 7 main issues within his 72 grounds of appeal. First, alleged violations of fair trial rights. Mr. Kanyarukiga submits that the trial chamber violated his right to a fair trial by denying his request for a stay of proceedings, by refusing to adjourn the proceedings on various occasions, by imposing arbitrary time limits on defense cross-examination, and by failing to timely rule on the admissibility of prosecution evidence. For the reasons set out in the appeal judgment, the appeals chamber finds that Mr. Kanyarukiga has failed to demonstrate that the trial chamber violated his fair trial rights. This part of the appeal is dismissed. Secondly, alleged errors relating to the indictment. Mr. Kanyarukiga submits that the trial chamber committed several errors in relation to the indictment. The trial chamber based Mr. Kanyarukiga's conviction for planning the destruction of the Nyange Church and the killing of the Tutsi civilians inside on three facts. Firstly, a conversation which Mr. Kanyarukiga had with Fulgencio Kayishema on the evening of the 15th of April, 1994. Secondly, Mr. Kanyarukiga's participation in a meeting at the Nyange Parish with Athanasis Arumba and others on the morning of the 16th April, 1994, at which the demolition of the church was discussed and agreed to. And thirdly, a remark made by Mr. Kanyarukiga after the meeting that the church had to be destroyed and that he would make it his responsibility to rebuild it in 3 days. The appeals chamber therefore declines to address Mr. Kanyarukiga's challenges to findings by the trial chamber that he participated in other meetings because any such findings do not affect the verdict. Regarding his conversation with Fulgencio Kayishema on the 15th of April, 1994, the appeals chamber finds that this conversation cannot form the basis of Mr. Kanyarukiga's conviction because it was not pleaded in the indictment. The chamber therefore disregards the conversation as a basis for Mr. Kanyarukiga's conviction. Finally, the appeals chamber dismisses Mr. Kanyarukiga's assertions that the indictment did not sufficiently inform him that he was accused of participating in meetings on the 16th of April, 1994, and that the trial chamber erroneously interpreted the allegations in the indictment concerning events on 16th April, 1994. Accordingly, the appeals chamber finds that Mr. Kanyarukiga has failed to demonstrate that the trial chamber committed errors in relation to the indictment, which would invalidate the verdict. Mr. Kanyarukiga's grounds of appeal alleging such errors are therefore dismissed. I turn now to alleged errors relating to the alibi. Mr. Kanyarukiga further challenges the trial chamber's assessment of his alibi. In particular, he argues that the trial chamber erred in drawing adverse inferences from the timing of the filing of the notice of alibi and list of alibi witnesses, to its assessment of the credibility of the alibi witnesses, 3, its treatment of its observations made during the site visit, and 4, failing to consider the laissez-passer allegedly issued to him during his alleged absence from Kivumo commune, and 5, its application of the burden and standard of proof to the alibi. For the reasons set out in the appeal judgment, the Chamber finds that Mr. Kanyarukiga has failed to demonstrate that the trial chamber abused its discretion by drawing an adverse inference against the credibility of his alibi from the fact that the notice of alibi and the final version of the alibi witness list were filed late. The Chamber further finds that Mr. Kanyarukiga has failed to demonstrate that the trial chamber erred in its assessment of the alibi evidence. In addition, the Chamber finds that Mr. Kanyarukiga has failed to demonstrate that the trial chamber erred in questioning the veracity of his alibi in light of observations it made during a site visit in 2010. Finally, the Chamber rejects his argument that the trial chamber erred in failing to consider the support given to his alibi by the laissez-passer and misapplied the standard and burden of proof to the alibi. Accordingly, the Appeals Chamber finds that Mr. Kanyarukiga has failed to demonstrate that the trial chamber erred in concluding that his alibi was not reasonably possibly true. His grounds of appeal relating to the trial chamber's assessment of the alibi are therefore dismissed. I turn now to alleged errors relating to the assessment of the evidence. Mr. Kanyarukiga raises numerous challenges to the trial chamber's assessment of the evidence. As stated before, the only evidence relevant to Mr. Kanyarukiga's conviction concerns his participation in a meeting at the Nyange Parish with Athanase Sarumba and others on the morning of the 16th April 1994, at which the demolition of the church was discussed and agreed to, and a remark made by Mr. Kanyarukiga after the meeting that the church had to be destroyed. This evidence was provided by prosecution witnesses CDL, CBK, CBR, and CBY. The Chamber therefore considers only Mr. Kanyarukiga's challenges to the credibility of these witnesses and their evidence on the meeting and his remark on the 16th of April, 1994. His other submissions do not have the potential to invalidate the trial chamber's verdict and are therefore summarily dismissed. The Chamber finds that Mr. Kanyarukiga has failed to demonstrate that the trial chamber erred in its assessment of the credibility of witnesses CDL, CBK, CBR, and CBY. Furthermore, the Appeals Chamber finds that Mr. Kanyarukiga has failed to demonstrate that the trial chamber erred in considering that these witnesses corroborated each other on the fact that a meeting at which the destruction of the Nyange Church was discussed and agreed to was held at the Nyange Parish on the morning of the 16th April, 1994. That Mr. Kanyarukiga participated in that meeting and that he made a remark after the meeting that the church had to be destroyed and that he would make it his responsibility to rebuild it in 3 days. The Chamber also finds that Mr. Kanyarukiga has not shown that no reasonable trier of fact could have concluded that the only reasonable inference from this evidence was that he participated in the planning of the destruction of the Nyange Church and the killing of the Tutsi civilians inside. Chamber therefore dismisses Mr. Kanyarukiga's grounds of appeal relating to the trial chamber's assessment of the evidence. I turn now to Mr. Kanyarukiga's position of authority and his motive to commit the crimes at Nyanje Parish. Mr. Kanyarukiga further submits that the trial chamber erred because it failed to rule on whether he was an authority at Nyanje and disregarded that he had no motive to commit the crimes for which he was convicted. The Chamber dismisses these arguments as they do not have the potential to invalidate the trial chamber's verdict. Finally, I turn to alleged error relating to sentencing. Mr. Kanyarukiga submits that the trial chamber imposed an excessive sentence on him as it double-counted sentencing factors, erred in its assessment of the gravity of the offense, and failed to take into account mitigating circumstances. He requests the Appeals Chamber to substantially reduce his sentence. For the reasons set out in the judgment, the Chamber dismisses Mr. Kanyarukiga's ground of appeal relating to sentencing. Let me now turn to the appeal of the prosecutor in his first ground. The prosecution challenges the trial chamber's finding that Mr. Kanyarukiga's conduct of planning cannot be a contribution to a joint criminal enterprise. The chamber declines to address this issue because, as the prosecution itself acknowledges, it has no impact on the verdict. In its second ground of appeal, the prosecution submits that the trial chamber erred in assessing the gravity of Mr. Kanyarukiga's crimes. It requests the appeals chamber to increase his sentence substantially, or to life imprisonment, or to remand the case to the trial chamber. The appeals chamber finds that the prosecution has failed to demonstrate that the trial chamber committed a discernible error in determining the gravity of Mr. Kanyarukiga's offenses. May I now ask Mr. Kanyarukiga to stand while I read the full text of the Appeals Chamber's disposition in this case. The Chamber, pursuant to Article 24 of the Statute and Rule 118 of the Rules, sitting in open session, noting the written submissions of the parties and their oral arguments presented at the hearing on the 14th of December 2011, dismisses Gaspard Kanyarukiga's appeal in its entirety, dismisses the prosecution's appeal in its entirety, affirms Gaspard Kanyarukiga's convictions for planning genocide and extermination as a crime against humanity, affirms the sentence of 30 years imprisonment imposed on Gaspard Kanyarukiga by the trial chamber to run as of this day, subject to credit being given for the period Gaspard Kanyarukiga has already spent in detention since his arrest on the 16th of July, 2004. Rules that this judgment shall be enforced immediately pursuant to Rule 119 and orders that in accordance with Rules 103B and 107, Gaspard Kanyarukiga is to remain in the custody of the tribunal pending his transfer to the state in which his sentence will be served. Judge Pokar has appended a separate opinion. You may now sit, Mr. Kanyarukiga, and I will ask the registry to provide the parties with a copy of the written judgment. The proceedings are concluded.
All rise.